Welcome to Divorces Schmidt, a family law series. In this episode, I'll discuss privilege issues related to litigation funders and whether communications between litigation funders, lawyers and parties are subject to discovery or subpoenas. It appears to be increasingly common that clients who have good prospects of obtaining a property settlement in a family law proceeding are unable to afford to pay their legal fees up front. At the same time, it's less and less common for lawyers to be prepared to run family law litigation on the promise of payment at the end of the matter. Litigation funders are often the answer to bridging that gap. Litigation funders assess the merits and prospects of a property case, necessarily with input from the client and the solicitors, and then agree to lend funds to cover legal fees, typically with some security provided by the client that's often recorded by way of a caveat on a real property. The information sought by litigation funders from solicitors largely mirrors the sort of information which a solicitor might provide to a client when advising on the merits of their case. Then when it comes to actually dispersing the funds, the usual process is that the solicitors provide copies of their invoices to the litigation funder, and the funder then pays the solicitors directly. So, what happens if the other party to the litigation demands discovery of communications with the litigation funder or issues a subpoena to produce documents directed to the litigation funder? Let's first look at the law of litigation privilege. Now, to avoid any confusion, I want to be clear. Family law in Australia is federal law, and so the Evidence Act 1995 of the Commonwealth is the legislation which applies, rather than any act of a state or a territory. Division 1 of Part 3.10 of the Evidence Act relates to client legal privilege. At common law, this is known as legal professional privilege. Personally, I prefer the term client legal privilege because the privilege belongs to the client, not to the legal practitioner. Evidence Act Section 119 relates to a particular kind of client legal privilege known as litigation privilege. And it reads as follows. Evidence is not to be adduced if, on objection by a client, the court finds that adducing the evidence would result in disclosure of a confidential communication between the client and another person, or between a lawyer acting for the client and another person that was made, or b, the contents of a confidential document, whether delivered or not, that was prepared for the dominant purpose of the client being provided with professional legal services relating to an Australian or overseas proceeding, including the proceeding before the court, or an anticipated or pending Australian or overseas proceeding in which the client is, or may be, or was, or might have been a party. Now, that's a bit long-winded and a little bit unclear perhaps on first reading. For the purposes of this discussion, where we're talking about the production of documents in an Australian family law proceeding, we're really just interested in two aspects of Section 119. Firstly, whether the document in question is a confidential communication, and secondly, whether the document was prepared for the dominant purpose of the client being provided with professional legal services. The term confidential communication is defined in Section 117, which contains the definitions relevant to Division 1 of Part 3.10. It says that confidential communication means a communication made in such circumstances that when it was made, the person who made it, or the person to whom it was made, was under an express or implied obligation not to disclose its contents, whether or not the obligation arises under law. Lawyers are obviously under both legal and ethical confidentiality obligations, so that part's pretty easy. But are documents prepared for the purpose of obtaining litigation funding prepared for the dominant purpose of the client being provided with professional legal services? There are two leading Australian authorities on this issue, both decided in 2006. The first is a New South Wales Supreme Court decision called Rickard Constructions Proprietary Limited and Rickard Hales Moretti Proprietary Limited. The second is a Victorian Court of Appeal decision called Spotless Group Limited and Premier Building and Consulting Group Proprietary Limited. In Rickard Constructions, Justice Bergen held that the dominant purpose of confidential communications with the litigation funder was to ensure the overall capacity of the plaintiff to have funding and to ensure that such funding would be forthcoming for the continued funding of the litigation. Just want to be clear, those fundings were in the judgment, they're not mine. The court concluded that the documents were privileged pursuant to Section 119 of the New South Wales Evidence Act, which is in identical terms to Section 119 of the Commonwealth Act. Spotless was determined on the basis of common law legal professional privilege, as Victoria had not yet enacted its current Evidence Act, which largely mirrors the Commonwealth and New South Wales Acts. Justice Chernow pointed out in Spotless that it is common ground that the original communication, namely the legal advice that was provided to the respondent, was subject to legal professional privilege. And it was that communication, that advice, that was passed on to the third parties. That the recommunication was in written form is, as I have said, irrelevant to this issue. What is of relevance is that on its proper characterization, the communication that was made to the third parties, effectively by the respondent, was the legal advice which it had received and to which privilege attached. In the family law arena, in the 2007 case of Blue and Blue, Justice Carmody, after considering Rickard's Constructions, Spotless and other authorities, found not only that the litigation privilege applies to communication between solicitors and litigation funders, but also that the principle was concomitant with public policy and that it was in the public interest for litigants to be able to access litigation funding. So the answer is pretty clear. Communications with litigation funders are covered by client legal privilege. I hope that this discussion has provided some value for you. If you'd like to be notified as I release further episodes of Divorce with Schmidt, please follow me on your preferred social media platform, subscribe on YouTube, or subscribe on your favorite podcast platform. I'm Johannes Schmidt. Thank you for listening.